Good evening and welcome to Florida Criminal Law TV. My name is Stephen G. Cobb, and we've been covering sexual battery offenses in this special segment of Florida Criminal Law TV. Now we're going to cover sexual battery where the accuser is over the age of 12. So these are not capital offenses. There are many different variants of them. And generally speaking, they all involve mandatory prison, sexual offender designation, sexual offender registration, and the possibility of a Jimmy Rice hearing. And a Jimmy Rice hearing is simply a civil commitment trial after someone who has served a sentence is then made a civil defendant for permanent lifetime commitment due to dangerousness. So these kinds of cases are very, very important when it comes to whether or not they're handled correctly. And I'm going to give you two examples of real life cases, again using anonymized names like Smith and Doe and things like that, because that's appropriate. So in my first example, a business owner had an employee and he asked a very simple question: why do you want to meet with me? And the employee couldn't really give an answer, but he relented, and in his mind, he was going to meet the employee at her normal location of work. Instead, she showed up to another location. And then after talking for a few minutes, she left. He thought, that's kind of odd. The next thing you know, an investigator is calling him, wanting to interview him about allegations of sexual assault and sexual battery. He's blown away and calls me immediately. I intervened, and it took 8 months before an arrest warrant came down. And sure enough, as the case is going on, here's some things we uncovered that played into the defense of this charge. Because these kinds of cases were real scary before the Me Too movement. They were one of the types of cases that you just can't get a fair trial on, to be blunt about it. You can get a trial as fair as possible. But even before the Me Too moment, it was very difficult, because when the question is asked, is there anyone here who would not want to sit on this case because they could not be fair, knowing it's a sex offense, you'd be stunned at how many hands go up in the air when we're trying to pick a jury. It's higher than for any other case. It always has been. And after Me Too, it's even higher. And this is a real problem for people who are falsely accused. So we started looking at motive, and here's what we found. We found, first of all, that the complaining witness, the accuser in the case, did not want to meet her boss at the business where the premises were rented. She showed up at the business where the premises were owned. That's curious. Next, we find out that she consulted not one, not two, not three, but 4 different plaintiffs' lawyers with her parents after the allegations. That's suspicious. And the whole time I'm thinking to myself that this looks like financial interest, but I can't prove it. So we took her deposition. And during her deposition, she testified under oath before trial, no, I'm not interested in money at all. What happened in those meetings with plaintiff's attorneys? Oh, I was just trying to understand my rights. My parents did most of the talking. I wasn't really paying attention. And you hear this all the time, I'm not trying to get money. I just want to make sure it never happens to anyone else. Now, sometimes when people are saying this, they're telling the truth. When she was saying this, she was lying through these things known as her teeth. Okay? How do we know this? Well, this was one of the very first Facebook discovery cases that was done in Florida. And trying to get evidence from Facebook or any other social media site is about like trying to pull teeth from a hen. It's pretty darn hard, even with tweezers and, an unconscious hen. However, we were able to do it as part of the discovery process. We compelled her to give us those private messages, not her public stuff. And so we proceed during trial. I release all this information to the prosecutor, who's still knowing that the complaining witness was going to lie on the stand, called her to the stand. Is that ethical? Apparently this prosecutor thought so. I don't think you call witnesses to the stand if you know they're going to lie. And the way they do the dance around that is they go, well, they might lie about this, but they're not lying about this, and I'm only going to ask about this over here that they're not going to lie about. It's like, come on, get serious. And she was serious enough to call her to trial, and we actually did have a trial with a 6-person jury. You don't get 12 in Florida unless it's a capital case. And in court, I busted her. And I said, didn't you say to so-and-so in a private message dated such and such a time, I'm going to get $300,000. She exploded into tears. The courtroom was cleared. And I immediately asked the judge to issue an order for contempt to eliminate acting in the courtroom. Boy, you should have seen the look on her face and that of the prosecutor. I thought both of their heads were going to explode. But this is a common tactic. The trial by tears, feels sorry for me. There's a specific jury instruction at the end of every trial that says sympathy or a desire to, take it out on someone because you're angry at them. Those are not lawful reasons to return a verdict. The lawful reasons relate to the evidence and the rules. So the judge didn't grant my motion, but the crying was stopped, and sure enough, she had to answer, yes, I did send that private message indicating that I would get $300,000. So then I hit her with the next one. Isn't it true that on a later date, you said, I'm going to get $300,000 and buy a sweet-ass truck, and you're going to be jealous? That's a direct quote. And she had to admit, yes, she did in fact say that. And then further on, the third one was, isn't it true that you were bragging just a few weeks before we got these records, which was real close to trial, that you were going to get $2.2 million and you wouldn't even have to go to court? Yes. Isn't it also true that 2.5 weeks, and I gave her the date and the time and the page number in this ginormous, I mean huge stack of information we got from Facebook, isn't it true that you repeated that claim of $2.2 million and embellished on it some more? Yes. Now, during the trial, the state objected when I wanted to ask her about her mental health medication because in her Facebook records we found, because I turned 18, I no longer can get my mental health medication, and the judge ruled against us on that. I thought it was relevant to show that this was someone who was either consciously lying or suffering a mental illness that detached her from the truth, but the judge did not allow that. Nevertheless, the client was found not guilty. And let me tell you, when you're standing next to somebody right before a jury verdict on a life-changing case, 2 things occur. When they leave the room, almost every client has asked me, what do you think they're going to do? And my response has been consistent for over a quarter of a century. You'll find out when I do. And secondly, you don't need to look over at that person to know they are utterly terrified that they can be wrongfully convicted. And this man was not. In the next segment, I'm going to talk about another type of defense other than financial motive, because that's what this defense really is. This was a financially motivated complaining witness who made the accusation. In the next segment, we're going to talk about a completely different type of defense. And as you can see already from this series, each case is different, even if the charge is the same. And even if the charge is not the same, you'll find recurring defenses. But in every case, they are very factually specific. A defense that'll work in one case won't even apply in another, and you'll see that in our very next video.